All right. So this is my colleague at Georgia Tech, Peter Swire. He's a law professor and a law practitioner. He's been really a leader in the privacy debates surrounding some, and particularly some of the issues surrounding the transatlantic data flows. And we were very excited to have him explaining the data privacy framework and assessing its prospects. And we also have Wolf Schünemann to discuss this from a European perspective after Peter is done with his presentation. So let's go right into it.
Okay, oops, sorry. Okay, hi everybody. So as Milton said, my name is Peter Swire, and I regret not being able to get to The Hague in person. I'd hoped to do so, but had some family obligations that interfered. What I'll do is just give a slide on my background on these data issues, and I'll focus on the announcement on October 7th, quite recently, of President Biden's executive order and the related regulation from the Department of Justice that is part of this EU-US data privacy framework. And the Commission, as part of the release on October 7th, had positive things to say about this, this change in US law. My own background on this topic is long, whatever other adjectives you could put on it. So way back in 1998, when the Data Protection Directive went into effect, I wrote this book called None of Your Business. It's a term that's been picked up by Max Schrem's group without attribution since then. And a year after that, I was asked to come into the United States government in the Office of Management and Budget to be chief counselor for privacy. This is when President Clinton was in office. And one of the things I worked on was I was the White House person for the safe harbor negotiations, the EU-US safe harbor negotiations, which were signed in 2000. So that was the first effort to have an EU-US agreement that could regularize the legal basis for data flows. Along with this, this attention to consumer privacy, but processing of personal data, I've also worked for a long time on the national security side, including an article called The System of Foreign Intelligence Surveillance Law that was published shortly after I left government, and trying to explain a then little known law called FISA, the Foreign Intelligence Surveillance Act. And it proposed quite a number of reforms, quite a few of which have now become law. In 2013, Snowden began his revelations. There's quite a good documentation that GDPR had been blocked in the EU Parliament. And when Snowden started to publish his things, the politics changed in Europe. And so GDPR followed as a straight line from the Snowden revelations, in my view. That summer, President Obama named a 5-person review group to say, what should we do about the NSA and all this? And I was named as one of the 5 people for that. We released a report that became, among other things, the basis for the USA Freedom Act of 2015, which was a significant reform to the NSA surveillance powers. In 2015, the Court of Justice for the European Union issued its first Schrems decision. And following that, there was a trial in Ireland that led up to what became the second Schrems decision. And I was, under Irish law, selected by Facebook to be an expert witness on US law. And the Irish law takes its independence seriously. And so once I was hired by Facebook, I couldn't talk to them again until the 300 pages of testimony had been submitted and presented in court. Also, coming out of the NSA review group, I began work on a project on government access to data for national security and for law enforcement purposes, and led the creation of a think tank called the Cross-Border Data Forum. We have regular postings on these issues, and you're welcome to subscribe to our postings email if you find that of interest. So I've been working on both data protection and EU-US relations and national security for, as I said, quite a long time. So here's a slide that this group probably understands well. Other groups I talk to, not so much. Why does the rest of the world care so much about EU privacy law? And we were just hearing about Brussels wanting to be relatively early to help form the playing field. Well, in a regime of privacy or data protection, it's typical to have a ban on transfers of personal data from the strict jurisdiction to the less strict jurisdiction, here from the EU to the US or India or China, unless there's still adequate protection or essentially equivalent protection of the data once it gets to the destination. Otherwise, you'd have a strict rule in Europe, let's say, and then it would go somewhere else and it could be posted to the internet and protections would be lost. Now, if the country is not adequate where the data goes to, and the US does not have an overall regime that makes it adequate, then increasingly over time under strict court interpretations, there are limited options for how the data can be transferred. And by far the most commonly used is what are called standard contract clauses, SCCs. And these standard contract clauses basically say, okay, we're a business, we have data within Europe, personal data about named individuals. And when it goes to the US or India, it still has to be protected at that same high level as if it's still European data. And the enforcement can be on the European side because there's an exporter of data who's subject to European jurisdiction. However, even this ability to transfer data has been called into question legally in the EU. So as I mentioned before, the Court of Justice for the European Union in the fall of 2015 struck down that safe harbor that had been in place for 15 years. The EU and the US hastily negotiated something called Privacy Shield that was signed a few months after the Schrems I decision. And then more than 2 years ago, in July of 2020, as this group knows, the court issued its Schrems II decision, which found that there were problems with the regime for transferring data to the United States. Even if companies had a contract that promised to treat the data the same as if it's in Europe, that wasn't good enough according to the court's analysis. And so since that summer of 2020, I think there's been a real question whether there was any lawful basis for a lot of transfers of personal data from the EU to the US or India or China. I don't think India or China have anywhere near the same rule of law protections around surveillance the US does, and the US had been found to be lacking. And so literally we've had a rule of law problem where it wasn't clear, and it's still today in some cases not clear, that there's any legal way to do business between Europe and the rest of the world. Okay, so how does that take us up to this October 7th announcement? In the Schrems decision, the court found there were two problems. They had two holdings that were saying the US system of government access to data was not good enough. The first, and the one that I've spent most of my time on and we'll talk about today, is that there wasn't a good enough system of what's called a redress for the EU citizens against the NSA. And it takes a second to understand this. So the basic idea is if you're in Netherlands, if you're in the Netherlands and you're worried that the Dutch government is doing too much surveillance, either for national security or other purposes, you as somebody in the Netherlands can file a complaint with your local regulators, and they will check to make sure that the law is being followed or not. And for instance, there's an oversight agency in the Netherlands that's quite active, and they would check to see whether the Dutch intelligence services had broken any laws. And if they had, they could say, for instance, delete this person's data. And so what the court was saying is, if data goes to the NSA, the US National Security Agency, that there has to be a mechanism for European persons to make sure the NSA is complying with fundamental rights protections of EU law. That's a surprise in some instances. Let's say the NSA initially saying, what, Europeans get to question our use of data in a different country? And the answer under the court's analysis is yes, it does. So that was one lack of protection, and the Privacy Shield protections, in my view, were not very good. They didn't match European legal requirements. The second issue, is the court said, is that the US surveillance for national security purposes is only permitted if it's necessary to do the surveillance because of some important goals such as national security, and proportionate. If you're doing it for national security, you can do this much, but you can't do unlimited surveillance. It has to be proportionate to the requirements of processing the data. So based on these two holdings, the Court of Justice struck down the European Union's Commission's finding that Privacy Shield provided essentially equivalent protection to EU legal standards. It's not a direct finding the US flunks. It was a finding that the Commission had flunked when the Commission said the US Privacy Shield was good enough. Biden and the European Union announced back in, it should be March, not May, my apologies, there was an agreement in principle. And then a couple of weeks ago, there was this announcement of this EU-US data privacy framework. There's details in it on redress from the Biden executive order and much more detail in the Department of Justice regulations. And notably, this regulation created the independent Data Protection Review Court so that European complaints could be resolved by this Data Protection Review Court. There are also details in the executive order on new limits on US surveillance, which can only be done now for newly announced and defined purposes. And for the first time, the US government accepted the European formulation that surveillance should only be necessary and proportionate. In the US legal tradition, you'd say things like reasonable searches and seizures, necessary and proportionate has not been part of US jurisprudence. But in a distinct change from Privacy Shield, the US government said that the US here going forward will only do intelligence collection and processing where it's necessary and proportionate for a goal such as national security. Now, I won't take too long here, except to say that the last 2 years have been sort of, for me, very, very wrapped up in trying to get to an answer on what to do for redress, because it turns out to be quite a challenging legal and political puzzle to do that. So the decision was announced in July of 2020. The next month with Ken Propp, a former US State Department counsel in Brussels, we did an initial proposal on how to fix redress. That had a bunch of problems with it. I testified for the Senate Commerce Committee several months later, and at that point was saying you might be able to get here without a statute, and we could use the Foreign Intelligence Surveillance Court, an existing court in the United States, to do a lot of these things. However, the European Union said that its view of the Schrems decision was even if you fixed everything about FISA, that wasn't good enough. The US government would also have to fix its rules around what's called Executive Order 12333, which is the executive order for how the US government does direct access, not through the companies, direct access to data. And there was no way to get EO 12333 to be looked at under the FISC for US legal reasons. So that whole path of fixing it through the FISC, of having that court make the decisions, turned out not to be possible due to the scope the European Union said had to be met. So that was the end of 2020. And then for the next year, working with Ken Propp, but also Theodore Christakis. Theodore Christakis is a professor at Université Grenoble-Alpes in Grenoble, and he's a fundamental rights, human rights professor expert on data protection in Europe. So with a European co-author, we wrote 2 articles that came out last January and February. The first one said you don't need a statute under European legal standards because an executive order is law under the US and can be recognized as law by the European Union. And so a non-statutory approach could be sufficient. The second article laid out a quite detailed framework or approach for how to do redress and how to create an independent authority that has the required effective remedy powers. And then last week on October 10th, a few days after the announcement of the executive order, the 3 of us wrote an updated article explaining how that approach from February had been built into the executive order and how the redress mechanism and Privacy Shield really does a very detailed and, in my view, good point-by-point meeting of the requirements of EU and US law. So now I'll just talk briefly about the 2 key criteria for whether this redress proposal meets European law, because you have a whole set of doctrine from the Court of Justice, and then you have a whole bunch of US constitutional and other restraints on the US side. So under European law, it's extremely important in data protection and in other settings that there be independence, that the person making the decision really is free from the executive here and can make an independent decision. And a lot of people naturally would think you'd get your independent decisions here by going to US federal courts. However, it turns out there's at this point, insuperable barrier to going to US federal courts. The US Supreme Court, in jurisdiction that I find too restrictive, but in jurisprudence, which is the Supreme Court's jurisprudence, has said that you really have to show an injury in fact in order to get to federal court. And the problem is legally that in Europe, any person, anybody who wants to, has to be able to make this complaint to get their data looked at without a showing of injury. And so there has been no proposal to date by anybody that would overcome the standing barrier and get these complaints to US federal court. Okay, so the natural independent decision maker is not available in the US federal courts. Well, it turns out there's an interesting trick where we can create this within the executive branch, but independent of the executive branch, which sounds odd. And that is through this technique of a Department of Justice regulation. And there's two Supreme Court cases very much on point. The first and most famous one is the US versus Nixon case during Watergate, where a regulation from the Department of Justice, a regulation said the special prosecutor is independent. And under the regulation, the special prosecutor can do what he or she wishes to do to investigate. And the special prosecutor wanted to investigate records held by the president. And even though the president objected and the attorney general objected, the special prosecutor won. And the Supreme Court said the reason is the law says, the regulation says that the special prosecutor wins. And in that case, they reaffirmed an earlier case on immigration judges called Accardi, which was similar. There was a regulation by the attorney general. The regulation said that these immigration judges would make the final decision. Then the attorney general didn't like one of their decisions. And the court said, well, attorney general, you wrote a regulation. While the regulation's in effect, the immigration judges make the final decision. You can't overrule it. So we have this strong Supreme Court upholding of the legal power of these Department of Justice regulations. And the regulation is stronger than the attorney general until it's repealed. And if it's repealed, everybody knows it's repealed. So this regulation creates the ability to have this set of judges, like the immigration judges, that are immune to having their decisions overruled. There's also, as we've gone through in our writings, independence in other key requirements under European law. The appointments mechanism has a great deal of independence for sort of outside experts who aren't part of the US government otherwise. The attorney general specifically does not supervise these judges. The attorney general can't fire the judges except for cause, like if they do criminal activity. And so in our legal analysis with the European lawyer professor and the American lawyer professors, we show why independence has been created even though it's in the executive branch. Also, to succeed in redress, it has to be effective. So there's two main steps for effectiveness. The first is these judges have to be able to do an independent investigation. There has to be, you have to turn over the rocks and look at all the classified data to make sure that the complainant's data is not being handled wrong. And step one in this approach is the Civil Liberties and Privacy Officer for the intelligence community goes first. He or she works with these agencies all the time, knows how to make the requests. But crucially for effectiveness, the Data Protection Review Court gets to ask for anything at once if it doesn't get enough from step one. And so there is, we conclude, independent investigation. These judges who are independent get to turn over the rocks themselves if they wish to do so. And at least as importantly, not only do these judges get to make an independent investigation, but their decisions have binding effect. The executive order says there's these judges over in the Department of Justice, but when they tell you NSA to do something, you have to do it. It is a mandate and order of the President of the United States, you have to do it. And so we then say there's effectiveness, and this independence and effectiveness are the key legal criteria for the European Union law, and they now comply with US law with this structure that's been created in this way. What happens next? The European Union has a process. On October 7th, the Commission wrote a very positive statement about the new changes in US law. The Commission then has to draft an adequacy decision explaining, like the one that got overruled in Privacy Shield, why the Commission thinks it's good enough. That decision will then receive comments from the European Union Parliament. The Libe Committee has typically been a strong defender of fundamental rights. And from the European Data Protection Board, those are the European data protection regulators. And after those comments are made, the Commission makes its final adequacy decision. And then we know what's going to happen next because Mr. Schrems has told us he will challenge it as legally not good enough to comply with the court's jurisprudence. What are the critiques? In the days since the 7th of October, there's a variety of critiques. The court's not this new court is not independent enough for various reasons. There's some people who say it has to be done by statute or it's not good enough. We've tried to answer that in previous writing. And very roughly speaking, I think there's a good argument the redress proposal will succeed. I think it's vaguer and less clear what's good enough to count as only necessary and proportionate surveillance. That may be a little bit in the eyes of the beholders. And if I were a betting person, I would bet that that's a tougher thing for this new agreement to survive. So I'm going to do two conclusions, one on this sort of legal basis, and then something I wrote overnight on political economy. So data privacy is data protection is a fundamental right in the European Union. You can't transfer data unless there's good enough protection. And the Court of Justice has clearly stated some of the requirements, such as redress concerning surveillance, that has to be part of any legal regime before data can be transferred. There were very difficult and complex institutional design challenges in the US. So these standing limits I talked about meant that nobody's been able to come up with a way to get to the federal courts. Independence is tricky to establish, especially in the US realm where there's a lot of people who talk about a unified executive. So how can you be independent, created by the executive, but not part of the unified executive? And the answer is that the president and the attorney general have given up some of their discretion, so they're able to do it. Also in the United States, national security is important. You know, national security for the intelligence agencies to see what's going on in Ukraine and to do lots of other things that the intelligence agency do, often in close cooperation with the member states. On redress, my own view is that it wasn't a question of a compromise. Instead, the institutional design problems were a Rubik's Cube. Once you get all the pieces together, there's one answer. There's actually not another proposal out there for how to meet all these requirements, except the one that we published back in February. There's been a lot of policy engagement on these technical issues. And to create a lasting agreement, there has to be rigorous compliance with a court that's been insistent on rigorous compliance. And so my own hope is the executive order creates ways to do that. Okay, so that's why this sort of odd Rube Goldberg complicated regime plausibly meets the requirements, but then I'll just have one other slide and stop. So I was thinking overnight about, this is a conference on political economy in the EU, and what is some of the political economy around personal data protection issues. The Commission has now, for the third time, Safe Harbor, Privacy Shield, and now the new framework, supported an agreement with the US that it's now saying is good enough to meet the requirements of EU law, and the Commission supports it. The member states and the Council clearly have indicated in various ways their continued support for commerce with the United States, because if you can't ship data to the United States because of US government surveillance, that applies across the board to an enormous range of commercial actors, including Volkswagen and SAP and lots of European-based companies that can't ship their data to the United States to do business. And then I think we have here a particular moment in time for the Court of Justice of the European Union. The Court of Justice has been notably strict in its jurisprudence on fundamental rights. And one of them is not just these data privacy cases, but there's been a series of cases that the European scholars are familiar with about what's called data retention, going back to Digital Rights Ireland case. And I think we're up to 5 or 6 times now the Court of Justice has said, governments, that's not good enough. You're holding on to too much data for law enforcement and national security purposes. You can't do it. You have to stop keeping these databases about criminals. Europol, you can only hold stuff for 6 months. And so there's quite a battle between where the member states are saying they need to do things for national security and public order purposes, and the court saying, we don't believe you. We think you're having infringements on fundamental rights when it comes to this data. Privacy Shield, in my view, was not a great deal in terms of meeting European legal requirements. I think my own view this time is the US worked on it for 2 years with Europe, and the US has modified its legal regime in good faith. So, you know, you go down the list of what the Schrems court said in Schrems 2, and the US has ticked those boxes. And so, you know, I think there's room for a good faith court to say that this upholds. But if the Court of Justice strikes it down again, and that's certainly possible, there may not be any US reforms left to make that are feasible, that people can imagine doing. This is Europe telling the United States how to run its national security and intelligence affairs. And the US has sort of bent itself into a pretzel trying to do that this time. And we may have a court saying you can't do something that the world expects people to be able to do, which is to have an internet and electronic commerce that includes the United States and Europe. So one thing I'll just point out, and this to me is an institutional design problem that Europe hasn't really faced yet, is that the Treaty of Lisbon, which is what gives the binding effect to the Court of Justice decisions such as these, the Treaty of Lisbon does not contain within it any provision for amendments. There's no 3/4 vote, there's no supermajority rules, there's no way to amend the Treaty of Lisbon unless you renegotiate, as I've been told by European people when I've asked them this, the entire Treaty of Lisbon, and that's really hard to imagine. So what if the Court of Justice stays strict? Even though Commerce and the Council and the Commission thinks there ought to be continued trade with the United States. And I think that there's a question for rule of law, there's a question for regime in Europe of a court that holds to notably strict decisions that cannot be achieved in its terms, even by political actors when they try to do that. So if Schrems 3 happens and it strikes down this US deal, we may really face much more something like a constitutional crisis where there may not be a way to paper it over. And especially when it comes to redress, they may be, the court, if it wants to insist on certain terms, might be asking for amendments to the US Constitution as a condition for being able to have trade with the United States. That's quite a strong place to be. So I hope this has been provocative. This has been my attempt to a complicated area, and probably I went on too long, but I'll stop there. Thanks.
Great. Thank you, Peter. That was very good. So now we're going to have a European perspective on this. What did you think of Peter's presentation, and what?
Yeah, I liked your presentation, Peter. So it's Schünemann speaking. So thank you for organizing this workshop and for the invitation, Milton. And I'm very excited that I can comment on your presentation. Maybe first I want to start with a disclaimer as well, as I'm not a lawyer, and I cannot challenge you with regard to the substantial assessment to be made on this proposal that you also have been very influential in putting together. So yeah, this is something you should not expect from me. But I liked your presentation. I especially also liked the last slide, which I did not know. Yeah, I knew the other slides already.
Sorry, I wrote it overnight. I apologize.
Yeah, no problem at all, because I think it relates well to 2 points that I wanted to raise from a political scientist's perspective. When now, because I mean, what you already mentioned, and this was also in your slides, that there is, of course, a lot of enthusiasm right now, which not in your presentation so much, but in many reactions. Yeah, this also comes from the first Commission reaction, right? But now, of course, the ball is in the field of the European Union, so the activity has moved to the European Union. There's a very complex polity now working with this framework proposal, and as you have also shown, there are many steps remaining. And so the first thing I wanted to say is, and this was on your slides, that of course it will be challenged, and it will be challenged on these basic elements that you have already mentioned. So is this really a court? What does this mean to be necessary and proportionate? And also the question of whether an executive order is enough. So this would have been my first point. The second point, because you could say that for Max Schrems and his people, this is pretty much a question of raison d'être, right? They have to challenge it somehow. But I want to point to, from this political science perspective, because I've worked on this GDPR process in the European Union as kind of a normative entrepreneurship by the supranational institutions in the European Union, mostly focusing on the Commission and the Parliament. But this was of course, also supported, assisted by what the European Court of Justice did, also in parallel to the GDPR negotiations. The first safe harbor judgment happened. Yes, so this was kind of something which can be regarded together. That this is somehow a normative project, and dilemmatic in the sense that the more this issue has been drawn into public attention, it becomes more problematic for supranational actors at the EU level to somehow let it being questioned, or to somehow having the impression in the with the populations that there is kind of a lukewarm compromise now that is somehow finding a way around these very strict rules that have been established and everything what supranational institutions are very proud about with the GDPR, that they have increased or have this extraterritorial effect. So this would be the first point. And there's a second point, and here I'm interested particularly in your opinion, because you have accompanied this process so actively. And this is the question when I worked on the GDPR for the first time, I mean, I did not really realize that it had something to do with intelligence services, right? I mean, this was regulating private actors when dealing with data. And so I think that it was never meant to regulating US bulk intelligence, I mean, although there is, of course, the Article 45, this mechanism, which was taken up from the DPD, but this is not kind of an innovation that the GDPR made. So it was kind of interesting that with this being channeled by this fact that this was being channeled by Max Schrems, somehow this aspect was drawn somehow into the center of the thing, So as you have mentioned, that I like that Snowden revelations really was a birth helper of the GDPR, while in essence, this was not about regulating the security sector and intelligence services. In fact, I mean, this is something where the European Union does not really have competence when it's about regulating the European Union, because this is national competence. So I found this interesting. And so for me also, I think that the European politicians, as you have mentioned on the last slide, are kind of a dilemmatic situation, because they could be more pragmatic, but now they are in this situation that there is Max Schrems as a kind of revenant also for them, always laying his finger in this open wound of how this can be dealt with, right? So I think that this is kind of a dilemma on both sides of the Atlantic. So I like your last slide, and I cannot challenge this substantively, but I think that these political logics also can be seen here as well, in order to get the outlook right for what is happening now on the European side.
But you said, Wolf, that the Europeans have gone out on a limb with their normative entrepreneurship, right? But can't they claim victory and say, we got what we wanted, we got what we needed? Why would they want? I mean, I understand why Max Schrems would want to stick to his guns even when there's no point to it, because I know people like that. They're motivated by kind of an ideology and a negative attitude toward the economic interests that are behind the transatlantic data flows. But the court itself, if it's really concerned about fundamental rights, they would have to, I don't see how the court would have this kind of political attitude towards norm entrepreneurship. Can you explain this?
Yes, one thing is that I think, I mean, I can maybe say least about the court, but I think that the supranational institutions in this polity are kind of defending the European idea, and this is of course something in this struggle about legitimacy for the European sake. I think the supranational institutions are kind of allies, right? And this is a masterpiece of this digital agenda, which is, I think, plays an important role in this new chapter on how this European raison d'etre can be defended. But it's true that when it comes to the question, the more technical question, how the European Court of Justice will rule, I'm not an expert. I will leave that to Peter. One thing that I should also mention, because I forgot in my first when I first reacted, is that you also have to look at political actors both at European and national level, because at the moment when the Snowden revelations hit and GDPR was already underway, they pretended that this would help against mass surveillance, and they could show that they reacted to Snowden revelations somehow. Yeah, although this had not to do too much with another. And so they could show, okay, we are doing something, here's the GDPR, while at the same time at national level, rather extending the rights for intelligence services and legalizing what has happened in the gray area beforehand and what was revealed also with Snowden revelations. So this is kind of a hidden chapter or a secret of this entire thing, which is now with every repetition of this Schrems, kind of.
Pierre has a comment.
comes up again.
I'll probably have to repeat it, but let's see if we can hear you.
Well, oh, I see. Okay, so I think, I think there's that political economy and analysis of a court is always tricky. We do have the same Justice von Domwitz, who's written all these decisions on both data retention and on the US Schrems cases. And what motivates him, some law professors in Europe have thought, is that data protection has become a way to have fundamental rights become a way to unify Europe, where the court announces norms that have to be upheld across the union, sort of looking into the court as an entrepreneur for how it creates a sense of Europeanness. I'm just reporting what other professors from Europe have said about that. In terms of GDPR, there was a logic, which is the PRISM program that Snowden talked about meant that Facebook and other companies were having data go to the NSA. Data would go from Europe to the US for Facebook or Google reasons. Then the NSA could touch it once it was in the United States. So there was a GDPR was supposed to slow down the storage of data in the United States unless there was good enough protections. But I do think that the court in the first Schrems case decided that GDPR had become an intelligence document where data couldn't go to other countries unless the foreign intelligence activities were good enough under European standards. That was a move that was far from obvious under European law or under GDPR. But once the court has taken that position, that's the court. That's the court that's been given by the Treaty of Lisbon final power. And so that decision changed what is possible for everyone else, because now the court has set itself up as the arbiter of foreign intelligence activities.
We have another question from somebody on the floor.
I just wanted to add on the court that you have to see the rest of the case law of the court on data protection. That the court came out super strong in Google Spain, for instance, stronger than everyone expected as a defender of the directive and afterwards the regulation, for the reasons I think that Peter mentioned. So it had to be consistent with itself. It's Schrems 1, Schrems 2, that was less of a, they still went the same way. What they would do on a third challenge, maybe their reputation is sufficiently solid now that on a couple of other cases they've backed down from a maximalist position on some cases, so maybe they will let it go. But I thought, why do you think it takes a constitutional amendment? I mean, I was looking quickly at Schrems 2. It's still essentially the interpretation of the GDPR. So you could also try to finesse it by amending the GDPR, no?
No, the court bases findings on the Charter, which is the fundamental rights document that's established under the Treaty of Lisbon. You could change GDPR, but that wouldn't change the Charter.
No, but I think, I don't know, maybe there would be a place to change the GDPR and still pretend that it's in line with the Charter, and then put the court in a position where it would have to find that the changes to the GDPR themselves were reaching the Charter, which is a taller order than annulling a commission decision.
Yeah, but I think, if you imagine going through Parliament in the Libe Committee saying that I think it would be hard to change legislatively, and the lawyers would say it doesn't matter. the lawyers would say there's direct operation of the Charter of Fundamental Rights here. That's as if in the United States, it's a direct operation of a constitutional amendment, and the US Congress can't change the constitutional requirements. And that's what I think from a maybe just too lawyerly a view, the court would be able to say that the legislation is really irrelevant now. This is Article 47 about a right to a tribunal. This is Article 6, 7, and 8 around the rights to data protection and privacy. And that can only be changed, as I understand it, by a change in the Treaty of Lisbon.
Yeah, that is correct. Yeah.
May I ask another very concrete question to Peter?
Sure.
Because I mean, you have been involved in this process for such a long time, and I'm really interested to know whether you would say that this is that was kind of an unintended consequence, because nobody really thought about something like prison when this was drafted already for the DPD, this adequacy decisions clause, or is this something which came out of this development passed independently? Or were there scholars and people really discussing this?
In Safe Harbor in 2000, which I was part of the negotiations, it was about commercial transactions. There was an exclusion of national security sorts of things, we thought. We didn't think that was what was on the table. It's that data can go from a data holder in Europe to a data holder in a third country with the right contracts or the right promises. And companies can't make the right promises when it comes to resisting a government court order. And so that was just outside of the scope of what we thought we were discussing. There were problems with the Safe Harbor legally. There were various ways you could have struck down Safe Harbor under European Union law. But what was very surprising to me, at least, was for the court to say it was now going to decide whether China and India and US had good enough intelligence protections that are outside the power of any company to change. That was a really remarkable move, but once they've made that move, that's now fundamental law in the European Union. It's not easy for them to pull that back. I don't know how trade with China, for instance, is legal at all. I can't figure that out, in the slightest extent. And the court hasn't really been bothered by that. They'll just keep saying you have to do what you have to do, and these are the standards.
Well, thank you very much, Peter. That's been quite enlightening, and